Preemption. In con law, our very first source of preemption is, that's right, the full faith and credit clause. So all states must respect the laws, the public records, and the official acts or the judgments and the judicial orders of other states. So the full faith and credit clause preempts states from judging or altering the judgments of other states. Full faith and credit, all states must respect the laws, the public records, the official acts, the judgments, and the judicial orders of other states. What this means in practice is that the actions of other states are res judicata in every other state, and the courts may not inquire into the merits. They may not inquire into the validity. They may not inquire into the legal principles of those cases. Decided in Illinois, res judicata in all 50 states. Full faith and credit. One exception. What if the court did not have jurisdiction over that case? Well, then the judgment would have no effect, would it? And full faith and credit would not apply. That is our only exception for full faith and credit. Full faith and credit to all the judgments, etc., of other states, unless the court that decided it lacked, that's right, jurisdiction. Okay, before we discuss incorporation, let's discuss state action. So, to be constitutionally protected, it must be state action, not private action. There are almost no restrictions on private action. Of course, we have the 13th Amendment, which gives private right of action for slavery, involuntary servitude, badges and incidents, or vestiges of slavery. But for the most part, to invoke the protection of the Constitution, the challenged conduct must be what? State action or actions by a private party that are fairly attributable to the state. The state action doctrine. If you want your rights constitutionally protected, it must be what kind of action? One, state action or conduct fairly attributable to the state. State action, easy. Fairly attributable, we will discuss. What this means is that the government cannot avoid the consequences of what they do by using private individuals or entities to engage in unconstitutional conduct against a person. So, for example, using private information, the government has to comply with the same constitutional legal requirements as if the government had obtained the information themselves. So if a private informant calls up the FBI and says, I have a tip to give you, and the FBI says, that's great, but we need we can still use you as the informant, but you have to do these things to comply with the law. That action would be, that's right, fairly attributable to the state, because the government told the CI, you must comply with all the standards we must comply to. Okay, so use of private information, government has to use, if they're using a private actor to do that, the government has to comply with the highest government standards to get that. But what's not state action? State regulations, state accreditation, state licensing. This does not rise to the level of state action that invokes the protections of the Constitution. Remember, we're invoking the protection of the Constitution for rights guaranteed by the Bill of Rights. So, regulation, what can the state regulate? Well, just about anything related to business, healthcare, industry, commerce. They can accredit schools. They can license nurses. They can license lawyers. They can partially fund. This does not rise to the level of state action. So regulations, licensing, accreditation, none of those things are state action. They're not transformed into state action. State action means that we are invoking the protection of the Constitution, and the challenged conduct must be by the state or fairly attributable to the state. Okay, let's talk about types of state action. There is our traditional public function, entanglement, or enforcement. Public function, entanglement, or enforcement. All right, so here we are talking about actions that are not necessarily state, but they are, that's right, fairly attributable to the state. A traditional public function, Marsh versus Alabama, a private actor performing an activity reserved for the state. What did they do in Marsh versus Alabama? We have a company town that was open to the public with grocery stores and libraries and streets. And so they could not violate Mrs. Marsh's First Amendment right to pass out leaflets. So traditional public function is our first type of action that is what? Fairly attributable to the state. The private actor is doing what? Performing an activity reserved for the state, like operating a town. Entanglement. The private entity is acting with state involvement or state endorsement. There's a close nexus or entanglement between the government and the private actor. What's a great example of this? Shelley versus Kramer. Here we have a racially restrictive covenant that was enforced by the judicial process, and that violated the Equal Protection Clause of the 14th Amendment. Entanglement, the private entity, the homeowners association with their restrictive covenant, acted with significant government involvement or endorsement. It was endorsed by the judicial process. Okay, also judicial enforcement is fairly attributable to the state. So here we have something that is, so remember Lugar versus Edmondson Oil. So Edmondson Oil used the judicial process to judicially attach Lugar's property. So they acted jointly with a private creditor to secure that property. Okay, so from Lugar versus Edmondson Oil, we get the Lugar test. The deprivation of the constitutional right must be caused by the exercise of some right or privilege created by the state, and the party who does the deprivation must be fairly characterized as a state actor. Okay. The deprivation must be of a right or privilege created by the state, and the person doing the deprivation must be fairly characterized as a state actor. That's our Lugar versus Edmondson Oil test. Okay, let's run through that one more time. Does the Constitution restrict private action? Not much, except if we're talking about the 13th Amendment. What's our exception to full faith and credit? That's right, when the court lacks jurisdiction over an action, then states aren't required to give full faith and credit. Can the government avoid the consequences of their actions by using private parties to act on their behalf? No, they cannot do that to violate a person's constitutional rights. Remember, we are talking about a right or privilege created by the state, done by a person who may be fairly characterized as a state actor. Okay, and we have three types of state action. One, traditional, that's right, public function, Marsh versus Alabama. Two, entanglement, acting with state involvement, or that's right, endorsement, Shelley versus Kramer. And then we have judicial enforcement, which is Lugar versus Edmondson Oil, which gives us our state action test. The deprivation of that constitutional right must be caused by the exercise of a right or privilege created by the state. And by deprive, the deprivation must be by a person, that's right, fairly characterized as a state actor. Let's repeat that Lugar test one more time. The deprivation of that constitutional right must be caused by the exercise of a right or a privilege created by the state. 2, the party charged with the deprivation must be, that's right, fairly characterized as a state actor. And that is state action.